will be talking about the children's rights perspective on surrogacy, with special regards to the parental filiation. So my presentation will include a brief introduction to the general problem of this issue, explaining what is surrogacy and what are the exact clash of rights between the applicants or the subjects of the surrogacy agreement. Then I will turn to explaining to you the general things to know about the establishment of parental filiation and what are the problems which arise in surrogacy in relation to that. Afterwards, if we have time, we will look at the European Court on Human Rights developments and also what the European Union, how it is issuing this issue at all, or is it good, is it bad? We will talk about that in the conclusion. So, as an introductory remark, assisted reproductive techniques are very controversial because they challenge the traditional family structures which have been really important from the perspective also to filiation rights to the national states, but these are very important from the perspective of children, especially in the surrogacy agreement, because the parenthood there is splitted, meaning that because of the unique combination of genetic, biological, social, or intent model, the child can have up to 5 parents based on what the national legislation tells or what the intent of the participants may suggest. That's why surrogacy has a really heterogeneous legislation in Europe and also overseas, and a common ground can hardly be established because of the different perspective and the deeply national traditions nation states include into family law, essentially. Yeah, we have to highlight that there is no comprehensive European legislation on family rights as it is family law, and especially the parental filiation, because it's not in the scope of the European Union but in the nation states. So what is surrogacy? So for those who don't know, what probably you guessed, surrogacy is a reproductive service which includes a practice of a woman getting pregnant on behalf of another using the IVF, in vitro fertilization, meaning that the surrogate mother who carries the child does not necessarily have to be genetically involved with the child, but she is the one who gives birth to this child. So that's why we can differentiate different types of surrogacy. The gestational one is the most popular one, as there the child is only related to the intended parents or a donor, and these arrangements can be ascertained based on altruistic measures or commercial. We know that commercial surrogacy is the most controversial one because it can hint some exploitation of women and children and so on. So that's why usually surrogacy as a whole practice means a condemnation from many societies and states. Okay, so the heterogeneous legislation causes that intended parents who cannot access surrogacy arrangement at home, they will travel to other countries to engage into the practice, then come back home with a child. So this is the question whether the nation state, the home state, actually recognizes this birth certificate which was created in a state where surrogacy was carried out. As surrogacy practice usually is not in line with the public order of the home state. So these are the clash of rights basically. How to ensure that the birth certificate abroad will be recognized in the home state, and how the parentage established on surrogacy arrangement can be recognized. These are the two factors which I will be more deeply talk about, but essentially from the non-recognition several other factors can arise and problems, especially for the intended parents. These things can include that the criminal proceedings can be launched against the surrogate, against the intended parents on the names of human and child trafficking as well as exploitation. The very much concerning is the ambiguous citizenship status of the child if there is no genetic relation between the intended parents and the child, and the enforceability of the surrogacy arrangements abroad. Yes. So we can see that the cross-border surrogacy arises because the intended parents want to circumvent the home legislation, which is usually banning surrogacy agreements, but necessarily they would like to establish a family by the methods of surrogacy. So let's look at the children's rights. We have been talking about that for a lot now, but the most concerning from the surrogacy perspective is the UN Convention on the Child's Rights, especially the child's right to identity, which is a really crucial factor in deciding the parental recognition and the best interest assessment. From another perspective, we can also tell here that the optional protocol on the sale of children can be, and it can basically be under the scope of surrogacy arrangement because it involves harmful practices like exploitation or selling a child, etc. However, there is no consensus that actually the optional protocol bans and involves surrogacy practices as well. We can have a debate on that after, but it is not necessarily explicitly established. So from European Convention framework, we will focus on Article 8, the respect for private and family life. So let's see what is the establishment of parental filiation, basically the legal affirmation and parentage what a child is included to. These are the regulations and rules how legal parenthood is established or annulled. So traditionally in the nation state we can observe that there are two presumptions of motherhood. So the legal mother is usually the birth mother of the child. Afterward it can be conquered by court judgment. From fatherhood, usually the first presumption includes the birth mother's husband. Afterwards, the man who asserts to be the father to the court, and then it can be the court judgment. In Hungary, I would like to highlight that they were really preservant about the emergence of assisted reproductive procedures. So in case when de facto partners enter into such services, the consent given to the medically assisted reproduction indicates the father of the child. But in case when a married couple goes to assisted reproduction, the first assumption, so the husband assumption, applies. So actually, whose child it is in surrogacy arrangements? We can see that determining parenthood can be established on several matters. In assisted reproduction, it is usually defined by intent. It is the intention of the intended parents to engage into assisted reproductive practices. For example, in the cases of donors, the donors do not intend to become parents, so they express their intentions not to. From this perspective, we can establish that assisted reproduction and parenthood is based on the model of intent, so theoretically we could apply this to surrogacy cases. But this is the problem that if we establish legal parenthood on a basis of a contract, it is actually a conventional taboo in many of our states because it questions a biological gestational truth, the standing of the birth mother. That's why the controversial matters very much is engaged with the parties, especially the birth mother status. So, what is the reality and how the European Court on Human Rights establishes whether they are establishing some interpretative pathways in regards to recognition of parental filiation when the child born from a surrogacy agreement? So we can say that as usually with assisted reproductive cases, there is no European consensus on whether surrogacy is lawful or non-lawful. That's why the states have a wide margin of appreciation, decide whether they allow it, on what grounds they allow it, etc. So, but we have seen that in surrogacy cases, when there is an existence of a genetic link between the child and one of the intended parents, it is a crucial point in determining the margin of appreciation of the state. I will talk about two cases which essentially are the same cases, but one difference is there which completely changes the outcome of the ruling. From this sense, also the advisory opinion on the Menesson case is quite crucial, which establishes, although it's non-binding, but establishes that some kind of mechanism such as adoption or something else shall be available to the child born from surrogacy, so to establish parenthood between the intended mother. So the court urges the states to at least establish some kind of mechanisms which can ensure in the future that the child can be recognized, the child's parent can be recognized. So the first case, the Menason against France case, involved a French couple who entered into a surrogacy arrangement in the USA, came back to France, but their application for the recognition of parenthood was completely declined. However, the court found, and they said that by this their right to private and family life was not respected because they could not have been together as a family, but based on the abroad established birth certificate, they were a family. So in this case, the child was a participant to the whole assessment of the private life aspects because the intended father was genetically related to the child. So in this sense, the court looked at whether the child's right to identity are somehow affected by the non-recognition, and then they find that they are, because the child, regardless of being from a descendant of a French national, was not recognized as a French national, so the non-recognition was against the biological truth. So we can see that when in surrogacy cases identity rights of the child arise, it causes a narrow margin for the states to decide whether to recognize the abroad certificate or not. In Paradiso and Campanelli, a really famous Italian case, also seemingly the same factual backgrounds, two Italians went to Russia to complete a surrogacy arrangement and came back with a child. However, here genetic link was not so the child was not related to the parents. This is why the child got the status of an undocumented minor, were given to foster care, and after one free to adoption. A violation here, however, according to the court, did not occur. And why is that? Because there was a lack of genetic link, which meant that the biological truth of being recognized as an Italian national was not necessarily relevant in this sense, and also the lack of family life between the intended parents and the child was not established because they were together only a couple of months. However, this interpretation of the court, what constitutes a de facto family life or what is the time frame, really like it's not so obvious, but in this case they told it was not a family life, so the whole proceeding was not concerning the child's rights at all. It was purely a case about the assisted reproductive procedures, thus indicating a really wide margin, meaning that there was no violation. We can say that in this sense, I mean, from a child's rights perspective, maybe this child was a bit neglected from the standpoint that there were intentional social parents who wanted this child to raised in their family, but intention as a parental filiation method or was not recognized in a sense. We can see that the genetic link and the existence of the genetic link is really crucial to what the margin might be in the human rights protection. So we shall conclude that the court relies on genetics over actually the social function on the definitions of parenthood. The European Union, what they do in this sense. We have heard a really good presentation on the children's rights perspective and what might the European Union have in hands with that. We shall say that family matters are always on the nation states. However, because of the free movement of the EU citizens, some public documents can be recognized in the sense of parental filiation as well to the child if they commute between the European Union states. However, there are still some national legislations which will decline the birth certificates established abroad based on the fact that it is maybe contradictory to their public order. That's why Council proposed a regulation on the European Certificate on Parenthood in 2021, which means that member states this regulatory framework will cover rules on international jurisdiction, also applicable law for the recognition of parenthood between member states, irrespective of how the child was conceived, born, and what type of family they come from. We can see that this specifically can be applicable to surrogate-born children, as well as rainbow families in another sense. So that's why I have told you the key provisions. So the recognition will have binding legal effect and will be established on the mutual trust between the member states. However, it's important to apply that the public order clause will be applicable for the member states if they find that this establishment of filiation is contradictory to their legal order. They don't have to actually recognize it automatically. This provision, however, was very much criticized by some of the MPs because they thought that it is a really big abuse of the European Union's power to enter into such deeply rooted family life provisions of a member states, which are generally established on traditions and the traditions of the society they cover. However, before the European Parliament it was accepted, and now we are waiting for the EU governments to decide by unanimity, which will probably take a long way to go, about the final version of the rules. So to conclude, we have said that the most problematic notion of surrogacy arrangement is the splitting parenthood, which generally is linked to the children's rights. The cross-border element is the one which brings in the most complications because the European legal system is diverse. We can see that the European Court on Human Rights is really decisive whether there is a genetic link established between the child and the parents, and it very much can rule a different ruling at the end. The European Union generally condemns commercial surrogacy because it's really problematic, but we see that they can introduce or would try to introduce some minimum safeguards for at least the children who are affected the most by these non-recognitions. We see that because of this proposal, that on the topic of parental filiation, they might be extended. It might be extended in interpretation on the way. However, the European Union might be really, how can I say, sensitive to let the EU actually tell what family law and parental filiation laws they shall recognize or not. Thank you for your kind attention.